Hello, everyone. Today we have a fabulous webinar conducted by Alex Barthet of the Barthet firm on Pay When Paid Sucks. So do this to get paid anyways. I'm Mariella Wagner, the founder of SunRay Construction Solutions, a national preliminary notice service. And without further ado, I will have now Alex Barthet. Please introduce yourself.
Good morning, everybody. My name is Alex Barthet. I am a board-certified construction lawyer. And today we're going to talk about pay-when-paid provisions, why they suck, and what you can do to get paid anyways. But at the same time, if you happen to be a general contractor, what you can do to make your pay-when-paid enforceable. So let's get started. So today's agenda is pretty straightforward. We're going to describe what a pay-when-paid provision looks like so that you can spot it in the wild. We're going to talk about the magic language that makes a pay-when-paid enforceable. And then we're going to break it down into two parts. If you are a general contractor, what do you need to do to make your pay-when-paid provision enforceable? This also applies, by the way, if you're a subcontractor and you have sub-subcontractors and you want that sub-subcontract to have a pay-when-paid, we'll talk about the things you can do to make your sub-subcontract pay-when-paid provision enforceable as well. And then as a subcontractor, what can you do to prevent the enforceability of the pay-when-paid provision? And then if you have any questions, we will answer all of them. The way you ask questions is go to the GoToWebinar chat box. Go ahead and submit your questions. Please do not include any names of people or companies in your question, and we will answer all the questions at the very end. So let's get started. What is a pay-when-paid provision? In its simplest terms, it is a written contractual provision. It has to be in writing, and it shifts the risk of non-payment from one party to another. So let me give you what is probably the most common example. If an owner doesn't pay a contractor, then the contractor doesn't have to pay the subcontractor. That is the classic pay-when-paid situation that we see on a regular basis. In Florida, it is a legal and valid defense to payment, meaning you as a subcontractor could have done everything right on the project. But if you sign a contract with a pay-when-paid provision and the contractor wasn't paid by the owner, then they legally do not have to pay you. So almost every contract that we see signed by our subcontractor clients and prepared by our general contractor clients have a pay-when-paid provision in it. It is very rare that we see a pay-when-paid provision or a contract without a pay-when-paid provision in it. So how do you identify a pay-when-paid provision? What does it look like? It requires certain very, very specific language, so it is easy to spot. So it typically requires one of two phrases: condition precedent or contingent upon. Those words are almost always part of the pay-when-paid provision. So let's take a look at a provision that sounds like a pay-when-paid provision, but is not. Under no circumstances shall the contractor be obligated to pay the contractor be obligated to pay the subcontractor until funds have been advanced by the owner. Now, you would read that and believe that that's a pay-when-paid provision, but the courts have looked at this exact provision and has said, no, this is not a valid or enforceable pay-when-paid provision. So let's take a look at another one. Final payment shall be made within 30 days of completion of the construction project, acceptance by the owner, and as a condition precedent, receipt of final payment from the owner. So this provision has been found to be a valid and enforceable pay-when-paid provision. So again, May sound complicated, but easy to identify. Almost always it will include either of those phrases, condition precedent or contingent upon. So if you are a general contractor, what can you do to keep your pay-when-paid provision valid and enforceable? So let's start from the basics. You need to have obviously a pay-when-paid provision in your contract. Sometimes we see general contractor clients have their standard either master agreement or standard subcontract agreement, but occasionally on smaller purchases, they may just sign a vendor's proposal. I would encourage you to have your own purchase order, maybe a one-page agreement that you give to vendors and subs that may be on the smaller side. So, you wouldn't necessarily give them your 10 or 15 or 30-page contract because maybe you're only buying $20,000 worth of materials or services, but you have a short form of your contract, maybe in the form of a purchase order, and that includes a pay-when-paid provision in it. Obviously, as we said, it has to include the condition precedent or contingent upon language in the pay-when-paid paragraph. Let's talk about what happens when you bond a job. If you bond a job as a general contractor, much more likely than not, your payment bond is not subject to the pay-when-paid defense. Let me explain what that means, because it's a big hole in the pay-when-paid defense if you've done everything right. Most bonds are what are called unconditional payment bonds. They have no direct condition on payment to you as a contractor on whether or not they're enforceable. So if you issue a bond, a payment bond on a public job, or you issue a bond on a private job, more likely than not, for sure on the public jobs, but much more likely than not on the private jobs, your bond is going to be an unconditional payment bond, which means that even if you have a valid and enforceable pay-when-paid provision in your subcontract, your subcontractor can make a claim against your payment bond surety, and your payment bond surety can assert all of the defenses you have except the pay-when-paid defense, which means that your surety may be obligated to pay an unpaid sub, and obviously your surety is going to come back to you to reimburse them, even if you have a pay-when-paid provision in your contract. So remember that if you bond jobs, then it becomes difficult to keep that pay-when-paid alive. There's another way that we see pay-when-paid provisions become unenforceable, and that is that you may sign a contract, and that contract says that contract incorporates by reference the prime contract, and that prime contract says that at the end of the job, you as the contractor are going to pay all your bills before you are entitled to payment. Well, that kind of does a number on your pay-when-paid, because you'll have to pay your subs before you're entitled to be paid by your owner. So what you need to do as a GC is a few things. One, you need to make sure that you have a provision in your contract that keeps your subs working even during the course of a dispute. Here's a sample provision of that. Subcontractor shall diligently proceed with the work during any dispute, even as it relates to payment or changes. The existence of a dispute shall not be the grounds for any failure to perform by subcontractor. This is important because during the course of any dispute, you have an obligation to keep working, so you want to make sure your subs keep working as well. So let's talk about it from the opposite perspective, which is, as a subcontractor, what do you do to make the pay-when-paid provision unenforceable? So the first thing you can try to do is try to strike the provision. That probably won't work. You can try to strike the magic language. that probably won't work either. Next, look at the prime contract, which is probably incorporated by reference into your subcontract. Most prime contracts say that at the time of final payment, the contractor needs to provide an affidavit or releases showing that he or she's paid all of their bills in order to be entitled to final payment. If that provision exists in the prime contract, then that provision will, when incorporated into your subcontract, likely invalidates the pay when paid. What does that mean for you as a sub? It means that if you can make it to the end of the job and you haven't been paid and the contractor wants to say that you are not entitled to be paid because they haven't been paid, that pay when paid provision becomes invalid at the time of final payment. So we've been successful in the past at invalidating pay when paid provisions on this ground. So the first place you want to look is the prime contract to see if it has such a provision in it. It's, again, a pretty standard provision. Even the AIA standard owner contractor contract includes such a provision in it. As a sub, obviously, if you have lien or bond rights, those lien and bond rights are not subject to the pay when paid provision. So if you work on a project, a private job, and the owner has not paid the contractor, you still have your lien rights. So while the contractor may not be obligated to pay you because there's a pay when paid that may be valid, you still have lien rights and you can proceed against the owner under your lien rights, making it even more important as a sub to serve your notice to owner timely and your lien timely. As I said as well, if you do work on bonded jobs, most payment bond sureties are not entitled to assert the pay when paid defense. The only time that a pay when paid defense is valid for a bond claim is when the bond is called a conditional payment bond. The way you'll know is if you look at the bond that was issued by the contractor, the title of the bond is going to say conditional payment bond. When that we could spend an entire webinar just talking about conditional payment bonds, but they're very rare. We don't see them very often. And the only thing to remember is that if the job is bonded with a conditional payment bond, then you need to do both, a lien claim and a notice of non-payment on the bond. The other thing as a sub that I encourage all of my subcontractor clients to do is to include a stop work provision in the contract. As I told you, the general contractor is going to want to say that you you must keep working no matter what during the course of a dispute. As a sub, you want to be able to stop work to the extent you haven't been paid. So here's a sample provision that you can use as a subcontractor. Subcontractor can slow or stop work without liability or penalty if it has not been paid its draw request in 30 days after submission. You know, maybe they don't agree to 30 days, maybe they say 45, 60, 90 days. The important thing as a sub is that you don't have to keep working indefinitely without getting paid. And the only way to ensure that you have that right to stop work is to have a provision in your contract that says you get to stop work. So if you have any questions, I encourage you to submit them now. If you want to learn more, we have a weekly podcast. So if you listen to podcasts, you can go ahead and subscribe to the Lien Zone podcast. And our next seminar, we have a live seminar we do several times a year, is going to be in Fort Lauderdale on October 22nd from 8 to 11. It's titled Getting Paid with Liens, Bonds, and Contracts. We take a deep dive into contract provisions, the lien rules and exceptions, bond rules and exceptions, and we focus on how to get paid for your work and how to minimize liability in your business. Again, that's October 22nd from 8 to 11 in Fort Lauderdale. And then we do these webinars every month for free from 9 to 9:20. The next one is on August 15th, and it's titled Change Order Headaches. This is your aspirin. And we'll talk about how to deal with change orders, the change order procedures that may be in your contract, and how to get paid for change orders before you do the work, which is always the most important way to do that. You can sign up for all of these events at sunraynotice.com/education. And with that, Ariella, do we have any questions?
We do not have any questions. Actually, there may be one. Hold on one moment. It just came in. So, good morning. In this case, you've referred to GC. Is it the same for interior designers and other professionals that may have subcontractors?
The answer is absolutely yes. This contract provision, the pay-when-paid, is enforceable in all levels and disciplines related to construction. So if you are a designer and you want to have your sub-consultants only be entitled to be paid for the work that they do, if you are paid, you would include a pay-when-paid provision in your designer contract, your designer sub-consultant agreement. Absolutely. Any other questions, Ariella?
Looks like you did such a brilliant job, and they wrote back, thank you very much.
Okay, great. Well, if you do think of any questions, anybody, you can send Ariella or me an email. We're happy to answer those questions later. And again, thank you very much, everybody, for your time. Ariella, anything else?
Amazing job as always, Alex, and I hope everyone has an amazing day. And again, like Alex said, if you have any questions, please feel free to send us an email and we'll make sure we respond to you within the business day. And have a fabulous rest of the day.